Okay, this is People of the State of Michigan versus Nicholas Diaz, docket number 21-25FH. And I'm told this is the time set for a no contest plea. And Mr. Diaz, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Diaz, you have the right to an attorney. You are represented by Mr. Austin, who is present. And Mr. Austin, again, this is a no contest plea to count 4. Am I correct on that?
That is correct, Your Honor, and the reason for the no contest plea is a lack of memory due to intoxication.
Okay, and you'll waive reading of counts 1 through 3?
Yes, we will.
Ms. Allen, would you read count 4, please?
Yes, Your Honor. I just wanted to double check. He was never formally arraigned. I think it was the date set for arraignment. Is it okay just to go forward with the plea before doing that?
Yeah, the
Okay.
plea takes the place of arraignment.
Okay, perfect. I just wanted to double check. Thank you.
Yeah.
In the People of the State of Michigan versus Nicholas Diaz, file 21-25-FH, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about November 15th, 2020, at 2222 West Holmes, apartment number 9, City of Lansing, Ingham County, defendant did in count 4 commit the offense of attempted assault with intent to do great bodily harm less than murder or by strangulation, that he did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or was prevented in the execution thereof, contrary to Michigan law, make an assault upon Taishia Plummer by strangulation or suffocation, contrary to Michigan law. This is a felony punishable by up to 5 years. Court shall order law enforcement to collect DNA profiling samples and was committed against the peace and dignity of the state of Michigan.
Mr. Diaz, you're being charged here with what's known as attempted assault by strangulation. That is a felony punishable by up to 5 years in prison. If you were on parole at the time you committed the offense, you'd have a mandatory consecutive sentence with your parole sentence. Have you had enough time to talk about this charge with your attorney?
Yes, ma'am.
Do you understand the charge against you?
Yes, ma'am.
Do you have any questions about what we're doing?
No.
And I'm told you want to plead no contest. Is that correct?
What does that mean?
It means that you don't have to admit that you did anything because of lack of memory. I'm just going to make findings, and then in the end it will operate the same as a guilty plea, but you don't have to admit anything.
Yes, ma'am.
That's what you want to do?
Yes, ma'am.
Okay, Mr. Diaz, if your plea of no contest is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with a trial. I'm going to go through those rights with you. You'll be giving up the right to a trial by jury, or if you didn't want trial by jury, trial by judge. You'll give up the right to be presumed innocent until proven guilty, and to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll give up your right to have the witnesses against you appear at trial and to be able to cross-examine them, as well as your right to have me order any witnesses that you might have to appear at the trial. You'll give up your right to remain silent at the trial and not to have your silence used against you, as well as your right to testify if you wanted to at the trial. Also, when you plead guilty, it changes some things about appeals. One is that you don't get an automatic right to appeal your case to the higher court. Instead, you have to ask them to hear your case, and they would have to agree to hear it. And second, when you plead guilty, there are many issues you cannot even appeal to the higher court. Unlike when people go to trial, if they get convicted, they can appeal a lot of things. Do you understand those rights?
Yes, ma'am.
Also, if I accept your no contest plea, it means that you will not be able to come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Understandable.
Okay, and it also means that you can't come back later on and try to say that it really wasn't your own choice to do this today. Do you understand that?
Understandable.
Okay, Ms. Allen, is there a plea agreement?
There is, Your Honor. In exchange for the defendant's successful plea and sentence To count 4 on the amended information of the attempt strangulation, the people agreed to dismiss counts 1, 2, and 3 and the habitual offender notice. There's also a misdemeanor pending in the 54A District Court, filed 20-3680-SM that we agreed to dismiss. And we will not be issuing any further charges with witness interference or threats as to conduct that occurred up to this date. There's also a sentence agreement pursuant to People versus Killebrew that the defendant's upfront jail will not exceed 12 months.
Is that a full and complete statement, Mr. Austin?
Yes, it is, Your Honor.
And Mr. Diaz, is that your understanding of the agreement also?
Can you explain it more to me?
Well, they're saying that they're going to, if you plead guilty to this attempted assault by strangulation that I already told you about is punishable by up to 5 years in prison, that they will dismiss the other charges and they'll also dismiss a misdemeanor charge, and they won't issue any witness intimidation charge. And they're agreeing about your sentence, that your upfront jail time would be no more than 12 months in jail. Do you understand that now?
Yes, ma'am.
And do you agree with it?
Yes.
Okay, and there is this agreement, like I said, about your sentence, that it would be no more than 12 months in jail. If for some reason I decided not to go along with that, I would tell you before I sentenced you, and I would give you a chance to take back this plea and start all over. You got all that?
Yes, ma'am.
Okay, has anyone promised you anything else that has not been said here right now in order to get you to plead no contest?
No, ma'am.
Has anyone used any threats to get you to do it?
No, ma'am.
Is this your own choice to go this way?
Yes, ma'am.
Okay, and then I've already been told intox, lack of memory is the reason for the no contest plea, and I've been provided in advance, thank you for that, a Lansing Police Department report that I have reviewed, and I find that all of these events occurred on or about November 15 of 2020, and all at the location of 2222 West Holmes in the city of Lansing, Ingham County. On that date at that location, Mr. Diaz assaulted his girlfriend at the time, and obviously did this on purpose, hit her all over her body. She was on the ground, and he put his hands, both of his hands, around her neck and squeezed her neck, restricting her ability to breathe. As she reported to the police, she was in and out of consciousness. Mr. Diaz's grandmother was there and saw the whole thing, and the police also observed physical injuries consistent with the strangulation. Has the court complied with MCR 6.302, Ms. Allen?
Yes, Your Honor.
Mr. Austin?
Court has, Your Honor.
Are you aware of any promises, threats, or inducements other than those already placed on the record? Ms. Allen?
No, Your Honor.
Mr. Austin?
No, Your Honor.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. Per the findings of the court, it supports a conviction on count 4 of attempted assault by strangulation, and a conviction will enter and the plea is accepted. Sentencing date is Monday, March 8th at 2:30. Mr. Austin, is that okay?
Yes, Your Honor.
Okay. So Mr. Diaz, do you think that you're okay with doing a sentencing the same way we did this plea, where you're in the jail instead of being brought to the courtroom?
Yes, ma'am.
You are, thank you. Then we'll do that on March 8th, and then we'll be remotely. And Mr. Diaz, you should just know that someone from the probation department is going to make contact with you so they can interview you. It's really important because it's for the report that I will use for sentencing. So unless you have any questions, Mr. Diaz, you are all set. You can tell them they're at the jail, that you're all done. Okay?
I got a question. Cause I'm on probation with Judge Allen. How would that work?
Judge Allen could choose to violate you on probation. I don't know what he would do.
He had extended my probation 6 months.
Knowing about this?
Yes.
Okay, then that's a pretty good indicator of what he's going to do, but I can't offer any guarantees. I don't know what he's, in the end, what he'll do.
I just seen him last Thursday.
Okay,
And he
well,
just extended my probation. He told me when I get released, contact him in 24 hours.
okay, well, I can't tell you any better than that.
All right, I appreciate it.
Sure, you're welcome. Okay, you can tell them then at the jail that you're all set.
Okay, you have a good day.
Thank you, you too.